Good afternoon and welcome to CUHK Law. My name is Stephen Gallagher and it's my pleasure to welcome you to today's Greater China Legal History Seminar. So our first seminar of this academic year, and we have a great topic for you and a great speaker with me today to present to you. Before I begin, I'm sure at the end, hopefully we'll have enough time for a few questions. So if you have any questions, please feel free to use the chat function to chat your questions into me and I can ask our speaker today. So let me introduce our speaker. So Sasha Allison is a practicing barrister in Hong Kong. While she's a specialist in family law, her personal interest outside of this area is legal history, particularly Hong Kong legal history. And Sasha recently completed her Master's of Studies in History at Cambridge and hopes to be able to add to the body of research on Hong Kong's legal history. So I think it was over 3 years ago that we discussed Sasha's interest in legal history and her topic, which is of course to do with pirates and the Admiralty Courts in Hong Kong. And at the time, I think she promised us that she would one day come along and present on this. So I'm very pleased to present Sasha to you today. I'll hand over to you, Sasha.
I did not think that Stephen would actually hold me to my promise. I know that Stephen has mentioned about pirates, but for those of you, I don't want to raise your hopes up, it's actually more on the Admiralty jurisdiction. Which is the focus of the talk today. So it's the Admiralty jurisdiction in Hong Kong between 1847 and 1849, and how that court actually dealt with captured pirates. And in particular, the focus will be on the pirates captured in the attack in the Chin Mo Bay. So this talk is going to cover the middle part of the process. And this has been described by historian Dr. Christopher Munn, that it's the process within the criminal jurisdiction between the capture and the sentencing of criminals. So our Hong Kong vice-admiralty court had finally been correctly established in January 1847. And the trial dealing with the Chin Mo Bay pirates exposed many of the shortcomings experienced by other British colonial courts around the world. And in particular, these trials exposed the flaws of when a state over-relied on convictions through obtaining evidence under the approver system when dealing with pirates as a collective predatory crime. Now, Sandra Freytag in her article, Crime in the Social Order of Colonial North India, described an approver system as where a member of a criminal gang who has participated in collective criminal acts of the gang then turns to give Queen's evidence and to assist the prosecution to secure a conviction against the rest of the gang. You'll notice that the talk about the Admiralty Court is only for 2 years, because this is the first version of the Hong Kong Admiralty Court, and it only existed for 2 years before sweeping reforming legislation was enacted in Britain, dissolving all the colonial vice-admiralty courts within the empire. So the talk will proceed roughly as follows. So firstly, we're going to look at the source material for where I've obtained information regarding the trial and the actual events. Then I'll look at the general significance of vice-admiralty courts, that followed by the jurisdiction and establishment of the Hong Kong vice-admiralty court. And for those who are still around, then I'll be talking about the tale of the Chin Mo Bay pirates, followed by the problems faced by the Hong Kong Admiralty Court, and then the trial of pirates and conclusion. Right. So in terms of source materials, main source of the trials came from contemporary newspaper reports. The Chin Mo Bay pirates attacked on the 6th of February, 1847, and it was reported by the China Mail newspaper 5 days later. This attack was by far one of the most daring acts of piracy at the time in terms of scale. And for the purposes of the talk, this piracy was significant because it was the first and major trial actually dealt with by the Hong Kong vice-admiralty court. So for those who have undertaken legal history research in early colonial Hong Kong, we all understand that there's a lack of official case reports for this period of time. And unless a matter was heard in the Privy Council or actually the Admiralty Court in England, there are actually no published case law relating to trials heard in the Supreme Court of Hong Kong or actually the Admiralty Court in Hong Kong. So most legal historians have had to rely on colonial newspapers at the time, reporting under the columns of Supreme Court cases or Admiralty Court cases. At the time, the newspapers that were available are the China Mail, the Friend of China and Hong Kong Gazette, and the Hong Kong Register. The newspapers would usually report the facts of the cases that came before the courts, verdicts, the sentencing, and sometimes they would comment on the costs, inefficiency of the courts, and miscarriages of justice. But not all cases were reported. So studying statistics is a bit difficult. So one of the government statistics does state that approximately 150 defendants were tried for piracy on the high seas in the Admiralty Court during the period of time that we're looking at. But not all these cases can be found in newspapers. So for an example, in April 1847, 4 pirates were sentenced to death for piracy and murder in Taitan. Nothing's been reported as to the crimes they committed or the facts that led to why they were sentenced to death. And the only thing that was published were the final confessions made by the condemned men to 2 Chinese Roman Catholic priests. So this is a copy of an example of the China Mail newspaper of 1846, I think. And my research has relied rather heavily on the reports set out in the China Mail, because this newspaper provided in-depth details of trials for the Admiralty Court. And on many occasions, the other newspapers used the articles in the China Mail in their own newspapers. So obviously, there are limitations in relying just on newspaper reports. Dr. Munn has also suggested that newspapers would have just reported on cases that would be of interest to their European community, and so there'll be a skewed view of crimes and court in general. And very rarely would newspapers record debates or arguments of legal principles if that was actually in fact raised at trial. So despite these limitations, historians have had to use these newspapers because there's an absence of judges' notebooks and case books, or they haven't been found anyway. And government statistics or official dispatches are highly unreliable. They would downplay negative views and exaggerate positive ones. So there is actually very little resources or other sources to corroborate evidence regarding convictions and acquittals, or actually any statistics in relation to the Admiralty Court itself. So one of the reasons why I've actually selected the Chinmo Bay trial was because it had the most detailed report of the actual incident itself. So we know what the acts of piracy were. And also it reported quite heavily on the piracy trials that took place thereafter, which then permits a study of the Admiralty Court's actual legal history and procedure, rather than just reviewing all the piracy cases before the Admiralty Court. Now, I talk a lot about the Admiralty Court itself. So to understand the significance of the Admiralty Court, one actually must appreciate the wider role these courts played within the British colonies. So Admiralty Courts were first and foremost meant to be imperial legal institutions. And British imperial legal institutions were deemed to be essential in securing the empire's claim to law, liberty, and property. And they were a defining feature of Britain's imperial identity in the 18th and 19th century. Now, vice-admiralty courts facilitated the reach of British law into oceans and seas under another sovereign's or empire's control. So setting up the Vice-Admiralty Court in Hong Kong extended the reach of English law and procedure into the South China Seas, particularly since Hong Kong Paramount's role was to be a naval base before it accidentally became a significant emporium of trade. So in order to fulfill its grand role in the empire's building plan, an imperial legal institution had to also convey fully colonial authority. Many historians argue that this was quite important in the establishment and founding of a colony, because firstly, the imposition of colonial rule of law was essential to the administration and enduring survival of the British Empire, hence why the British laws and legal institutions were imported. And also, colonial courts was a crucial theatre to display such colonial power. Another display of colonial state power in some colonies was policing, but the colonial court itself was a major legal institution. And so the form of address, costumes, customs was similarly imported, wholesale from the English metropole to the furthest fringes of the empire. So I'm going to digress very little bit to actually explain the history of the Admiralty jurisdiction itself. I'm not going to go very long because there is several thousand years worth of legal history there. But just to stress how important Admiralty jurisdiction is, waterborne commerce had developed very early in history. And Admiralty law had evolved from just universally understood custom practices on the water. And these principles came about 3,000 years of recorded history in medieval continental Europe. This means that Admiralty law has roots in civil law as opposed to common law roots and case law and practices. So this in turn had implications in the criminal trials held under Admiralty jurisdictions, especially when these criminal trials were then practiced in medieval England. And that resulted in conflicts between the common law courts and the Admiralty Court. So originally, the title of admiral was already common in Europe by the 13th century, and an admiral was just a naval field commander, but he was appointed by the crown, and he was an officer of the crown. And his duties were mostly military until the 14th century, when piracy became rampant in the English Channel. Now, to cope with the rise of piracy with the English Channel, the scope of the admiral's powers was broadened by the court, by the English king. And this is what it's described by the letters patent. And this is actually an example of what a letters patent like from Edward III. Not the same one. So even before the scope of duties of the admiral was expanded to protect the coast, administer justice, collect payments due, and suppressing piracy, English common law courts themselves had already exercised jurisdiction to deal with maritime cases. So there was obviously going to be a conflict in terms of the sphere of jurisdiction between the Admiralty Court and those common law courts. So I'm going to now condense even more and fast forward Admiralty legal history. So the statutory definition of the Admiralty was vague enough that the Admiralty Court began to hear cases involving foreign trade and nationals, which local courts couldn't hear since it was outside the realm. And this in turn precluded common law courts hearing cases involving foreign parties, ships, or goods not within the county. This led to foreign merchants tending to favor the royal court because of its wider jurisdictional reach, and also because the civil law-based rules and practices would have been familiar. And that in turn led to the increase of business conducted within the Admiralty Court jurisdiction. So why is this significant for Hong Kong? So the significance lies in its history, that because the Admiral or Admiralty Court was appointed in England by the monarch through the granting of the royal warrant, the Admiralty Court was the only court that could be granted by imperial assent and not by local colonial legislation. And this very point explains why the Hong Kong Admiralty Court was only established correctly in 1847. So since the English, and just to clarify, since the English High Court of Admiralty was an imperial court, colonial courts granted jurisdiction over Admiralty matters obviously were subordinate to this imperial court. And technically, I really should be calling Hong Kong Admiralty Court the vice-admiralty court. But for convenience, I'm just going to use this term interchangeably because otherwise there's a lot of words. So then moving on actually to our Hong Kong Admiralty Court and what jurisdiction it had and its formation. Just discussed that law was one of the central pillars of colonization, and often the first step in establishing the new colony was to institute a system of criminal law to strengthen imperial rule and domination over the colony. And the British obviously took great pride in their legal system, believing it to be a superior form of justice to all other systems. And the British also believed that it suited the needs of colonial government, And it afforded familiarity to the British traders engaged in commercial activity throughout and in the periphery of the empire. So this is the map of China as at 1843. And if you look right at the bottom, there's a tiny little red star there. And that's the island of Hong Kong. So in 1841, the island of Hong Kong was at the periphery of the Qing Empire. You know, the island's hilly terrain hosted small Chinese population. It was previously unexposed to any foreign presence or actually any official governing establishment of the Qing government itself. And it did give rise then to Hong Kong becoming an established haven for pirates and bandits. And the British were actually greeted by an impoverished native population of Hong Kong, which have been described as degraded quarrymen, smugglers, fishermen, and pirates. Now, as we all know, neither the British or the Qing governments were pleased with Captain Elliott's ultra vires proclamation on the 29th of January, 1841, regarding the ceding of Hong Kong under the Convention of Chunping, which was why it was not ratified immediately. So what this meant was that while formal negotiations were continuing between the British and Qing governments, little was done to formalize law and order in Hong Kong. Now, British colonial policy had always been pragmatic in terms of whether it imposed or adapted its law respectively to the colony that it was taking. So where a sector of the colony was fundamental, such as commerce, trade, or security, Britain as the colonizing state consciously imposed its own legal systems and control. However, on the other hand, if there was a change to the colonial legal system, threatened the stability of the colonial rule, then the British common law system would not be imposed strictly, but adapted to local circumstance. Now, the Royal Charter of 5th of April, 1843, which followed the formal ceding of Hong Kong, made no reference to the state of existing law in Hong Kong, thereby obliterating any ties and applicability to Qing law or Hong Kong or the surrounding seas. Why is this significant? Well, because even though Hong Kong was a remote outpost of the Qing Empire, the island was still part of a large Canton Delta, a region of the Qing Empire that had a very long tradition of commercial activity, overseas trade, and piracy. So considered consequential jurisdictional jockeying was a universal and regular feature of colonial order, even in archetypal non-state space of the ocean. The supplanting of British laws on piracy was not a premise accepted by the Qing Empire, particularly in the arena of how pirates should be dealt with, and also the cultural philosophy between the Qing and the British legal systems. So, having carved out the island of Hong Kong by Royal Charter, the next piece of legislation extending British sovereignty was the Supreme Court Ordinance of 1844, which declared the laws of England to be enforced in Hong Kong. The trouble with this piece of legislation, insofar as it relates to our Admiralty Court, was that it conferred upon itself inappropriately the jurisdiction of Admiralty. So I mentioned Admiralty jurisdiction was within the sole prerogative of the imperial legislature, not colonial legislature. So technically, all trials heard by the Supreme Court between 1844 and 1847 were void. Now, this problem of extrajudicial reach is not unique to Hong Kong. Singapore and New Zealand also committed the mistake. What I think is inexcusable for Hong Kong was that Lord Stanley had actually issued a circular to all the colonies back in 16 December 1842, quite clearly stating that colonial legislation could only cover acts taking place within 1 league from the shore of the colony and related to matters of local interest. So accordingly, any colonial legislation made to take effect on the high seas at a distance exceeding 3 miles from the shore of the colony were null and void. Well, unsurprisingly, Section 22 of the Supreme Court Ordinance was repealed the next year. So that also then meant that very little action was taken by the Hong Kong colonial government to pursue, capture, and prosecute pirates, because there was a lack of jurisdiction to try them in Hong Kong. And I believe that this legal lacuna could explain the practice from 1844, where the colonial government would render to the Qing authorities pirates captured by the British Navy as a matter of routine for summary trial and execution. Now, the Qing authorities obviously accepted this practice as a matter of course, because to them, you know, they had still retained sovereignty of all Chinese, notwithstanding all the British royal charter, and their sovereignty extended even to those in Hong Kong, which in turn, by having this practice, would have diminished the way the Qing authorities viewed the British sovereignty in Hong Kong. So this unsatisfactory state of affairs continued until the letters patent granted by the British imperial government dated 10 January 1846 arrived in Hong Kong. And finally, they appointed commissioners to hold Admiralty jurisdiction within Hong Kong. And the Hong Kong vice-admiralty court was then established and sat for the first time on the 14th of January 1847. Now, in theory, the Admiralty Court was to protect British trade and was to act as a counterpart to British warships' role in ensuring safe waterways for commercial vessels. However, in practice, this was very different. The majority of defendants in the courts were Chinese, and they were tried for very petty crimes. So even Europeans that were tried for petty offenses. So, for example, there's a session on the 8th of October, 1847, involving a mariner, Daniel Hill. He was only charged with stealing a case of sherry brandy, being the property of Captain Passmore. He was actually found not guilty after trial due to insufficient evidence. Other problems in practice was that obviously no one actually raised jurisdictional questions as to whether the criminal acts occurred in Hong Kong or Chinese waters, which you will see when we talk about the Chimo Bay pirates. And the Hong Kong Admiralty Court actually only dealt with piracy cases, so only dealt with criminal jurisdiction. And it didn't deal with cases such as price or wreckage, which would have brought in considerable revenue, meaning that this was a very expensive exercise to keep the Hong Kong Admiralty Court running. So, you know, having set the scene and the background, let's turn now to what we've all come for, which is piracy. So a modern jurist would immediately query what elements were required for a criminal act of piracy to have been committed in the 19th century. However, during a large part of the time when Britain ruled the waves, the law of England relating to crimes on the high sea was surprisingly difficult and obscure to define. So this is a copy of the Piracy Act of 1847. And for those of you that can actually read the very small script, you will see there's actually no statutory definition of what constituted piracy. And this actually goes all the way back to, I think, Henry VIII's piracy ordinances that he brought in. There's actually no definition of what piracy means. So this lack of precise definition should have and would have impaired the ability of any vice-admiralty court to try piracy trials fairly. I mean, even the expression high seas is not without ambiguity, since territorial seas was not a term recognized under common law. And the extent of the Admiralty Court's jurisdiction was also determined by the tide. So if we're talking about high seas, the high water mark was the limit of the jurisdiction of the common law, while Admiralty cases fell beyond the high water mark between the ebb and flow of the tide and below the first bridges on the tidal rivers and creeks. So this means that you actually needed to know the tide charts and whether the rivers were actually part of the common law or whether the Admiralty jurisdiction covered those sort of things. So this meant obviously that piracy as a legal concept could and was often applied flexibly depending on the circumstances. I mean, this vagueness did not hinder judges or juries in practice, and they tended to conflate piracy as a form of robbery on the seas. I mean, from a strict legal perspective, this was not correct. So Sir Edward Coke, the great English jurist, had previously suggested piracy was not a crime, which was derived from the common law tradition of case law, and rather its roots were based on the civil law tradition of continental Europe. And although piracy shared elements with felonies like robbery, it should not be regarded as such. But this doesn't change, this legal definition did not change contemporary views of piracy. And this can be seen in a dispatch written by Consul Sir Rutherford Alcock to the third governor of Hong Kong, Sir George Bonham, in July 1848, relating to another case, stating that first, piratical acts were against the law of nations, and secondly, piracy is defined to be robbery and depredation upon the high seas, without any authority from any prince or state. And it was even held to be piracy when a man, having a commission or lawful authority to whom he is not warranted to fight. So everyone just understood that pirates were long considered enemies of mankind, and that was a tradition that just continued. So for the purposes of this talk, piracy will mean criminal acts committed upon the high seas, and at the time of commission were deemed to have occurred without state sanction against ships friendly or hostile to the state. Right, so obviously, having no definition, reception of piracy laws into Hong Kong was not a straightforward exercise. And in 1847, Governor Davis tried to implement colonial anti-piracy legislation, but this was disallowed by the British imperial government on the basis that the colonial government had assumed for itself powers which it did not belong to it. So again, we go back to the question of where jurisdiction comes from. It has to come from the crown. One thing that would be interesting to also look at, because pirates around Hong Kong were just as likely to be caught by the Qing Navy when the Navy actually got involved from time to time, as a matter of comparison, to look at how the Qing government empire looked at on piracy. So crimes in China were viewed as a breach of social harmony, and restoration of equilibrium was of paramount consideration. So crimes were classed according to the threat levels against the existence of the state. And Ernest Alabaster, in his book, Notes and Commentaries on Chinese Criminal Law and Cognate Topics, classifies offenses against the state into three categories. First, there were cases that directly and primarily placed the head of state, so the emperor, in danger. Second, were cases where the existence of the state is directly and primarily imperiled through the head of state. We're talking like rebellion and sedition. And third, were cases where the existence of the state was challenged by destroying proper confidence in the state. So we're talking about counterfeiting, and piracy obviously fell under the third class. So law and punishments were consequentially quite severe. So we looked at the law. Let's look at who our pirates are. Now, there's been a lot of work done by many historians regarding pirates. And my work only looks at pirates for a very short period of time of 2 years. So works done by like Robert, Anthony, Diane Murray, and Grace Fox have looked at the world of pirates of the South China Sea and looked at reasons why geopolitical upheavals, natural disasters, cause general population to turn to piracy. And this period of research usually ends about 1810, although the Grace Fox research has looked at the grand pirate fleets that vanquished for a period of time. But this period of time that I look at, there are no grand pirate fleets at all. And the main theme that comes out of the existing research relates to the pirate themselves, about how they're drawn to the bandits' life and how the British or Qing governments responded and dealt with these bandits. And on occasion, and by some historians, depending on the period of time, they talk about these pirates being a subverting resistance against the state. But obviously, I would suggest that not all social banditry are an expression of social protest or rebellion. My pirates, who had the misfortune of being caught and tried in Hong Kong Admiralty Court, were just a sad bunch. They were groups of men, commonly referred to as petty pirates, who came from the laboring poor. Usually, but not surprisingly, they were fishermen, and fishermen were described as China's poorest. These individuals were highly mobile. They lived on the fringe of respectable society and earned only a subsistence living, which they had to supplement through piratical forays. The fact that they had easy access to vessels to plunder obviously was a clear benefit. Now, petty piracy and fishing has always been complementary in the South China Seas, and this type of activity was predicated on the seasons and the winds. Summer was pirate season, and autumn was the season for fishing and staying at home. So petty pirates also came from other groups of laboring poor. These men, and it's usually men, they were driven from China due to recurring natural disasters of poor harvests, food shortages in the preceding years, and they were drawn to Hong Kong by promises of work, new opportunities, and escape. And because of the influx of all these laboring poor, they created a surplus supply of labor. They were also considered, I mean, not only were the poorest elements of society, but they were also considered traitors while having left China and living under Hong Kong. Hence the high-handed way of the Chinese summarily dealing with them when they were caught. So although commercial opportunities in Hong Kong was increasing, demand could not always keep up with the supply. So when these men were pushed to the brink, they had to take to piracy as a necessity to survive. So definitely, I would say, not a social resistance to state control. Another factor why I say that these group of laboring poor itinerant migrants in early Hong Kong were lured into criminal activity was because this group of men didn't have the restraint of family, village supervision, marital responsibilities, or lineage ties that would have traditionally maintained some control over these men. And so I would say that my thesis that pirates of this period of time tended to just be one of survival. Right, so now we come to Chin Mo Bay. It's that little red dot up there, and Hong Kong is all the way on the left side, right at the bottom. The Chin Mo Bay was a sheltered bay in the Fujian coast used by some traders like Jardines and Dent to illegally trade in opium and cotton before the treaty ports were open. And since opium was traded in silver, it was irresistible to pirates. The thing was, the Chin Mo Bay piracies of February 1847 against the receiving ships was so devastating that trade actually got located northward. But if you look at the map, it's quite obvious that Chin Mo Bay is actually far outside the waters of Hong Kong. Obviously, the newspapers did not elaborate why all the piracy trials were held in Hong Kong. But I believe that the fact the attacks were made against British vessels brought the matter under the Admiralty Court jurisdiction. And this is the report that I will summarize. You don't have to read it. The words are very small. So what happened was, basically, the pirates attacked two schooners, the Omega and Caroline, who were carrying opium. And the pirates came in 3 fishing vessels, and they robbed them of all their treasure, save for 15 chests of opium. And when both schooners were brought into Hong Kong, there were signs of a desperate struggle that have taken place on both ships. And both captains were lost, and the crew had been killed. So the evidence that was obtained and reported in newspapers actually came from survivors of the Caroline and Omega and was taken by the chief magistrate in Hong Kong. So it does show that the pirates had actually carefully planned the attack. So 3 days before the attack, 2 large fishing vessels entered Chin Mo Bay, while a third anchored outside. Boats from the schooners were sent off to examine the fishing vessels and ask them what they wanted. And in the beginning, the pirates pretended that they were fishermen, that they were dealing in salt, having come from Hong Kong and were returning there. I mean, they really should not have been believed according to the newspaper because they were disproportionately armed for fishing vessels. They had 5 to 6 guns, plus gingals and other customary weapons, much more than you would expect for a fishing vessel. So over the course of the next 2 days, and to keep up with the rules of being fishing boats, the two pirate boats left the bay at sunrise and returned in the evening. And then by the third evening, they had obviously lulled the Omega and Caroline into the full sense of security, because that's when they launched their attack. When they returned to the bay, the pirates positioned themselves on either side of the Omega and started throwing fireballs onto the deck of the schooner. And then while the pirates from one boat was boarding the Omega, the other one sailed over to the Caroline and attacked it in a like manner. For some reason, both schooners were completely unprepared for the attack. None of the guns were loaded, and those on watch on the Omega only knew the pirates were on board when the pirates were actually among them. They didn't have enough time to raise the alarm, and only the chief mate and gunner had enough time to obtain arms to counteract the pirates. Reading the China Mail is actually quite funny because they have very little sympathy for the schooners. They criticize their mismanagement and lack of vigilance on the part who had the responsibility of safeguarding the crew's life and very valuable property. The newspaper complained the ships had ample means and opportunity to defend against a pirate attack when they should have been suspicious of the purpose of the shipping vessels. But no steps had been taken to load the guns or place the men on watch. The captain and crew of Caroline were also lampooned for their lack of courage, having fled the schooner instead of defending the ship, because they immediately gave instructions to lower the longboat to be able to run away. And both captains of both boats died during the attack, having not made it through. So the booty removed by the pirates was estimated to have been immense. On board the Omega, there were 60 chests of Patna opium, which I think is the best quality of opium, and 40 Benares plus Malwa and Turkey opium. The estimated loss for the Omega was placed at 110,000 at that time, while Caroline's loss was about 50 chests of opium plus treasure in boxes, and the iron chest was said to be valued at approximately $60,000 at that time. So that's the article. Carry on. What is a 19th century criminal trial like? Well, it's a lopsided contest. It's in favor of the state, and more so in colonial courts. You know, the colonial government was both participant and referee, and sets out the rules and sanctions for breaches. And because the rituals were imported from another jurisdiction wholesale from Britain, it was imported upon a person from another culture and life situation in the periphery of the empire. And 19th century colonial defendants lacked legal representatives generally at criminal trials. Many writers have criticized this, but they also fail to place it in context that it was only in 1836 in England that defendants had the privilege of defense counsel to sum up the evidence and address the jury. So it didn't take the colonies too long to actually adopt this practice as well. And also, you know, in Hong Kong, like other parts of the British Empire, prosecution was professionally trained while the accused were their own counsel, commonly unaware of their rights to submit evidence to the court or to call witnesses in their defense. So having so many elements in the colonial administration's favor, you would then expect the Admiralty Court to be a finely tuned instrument for delivering the right outcome according to state. But this obviously was not the case. The problems with the colonial Hong Kong court was that the most obvious one was obviously language. You know, judicial officers, juries were all European, while the preponderance of defendants and witnesses were Chinese. And these defendants and witnesses would have been lost at sea with the foreign court dress, court procedures, imperfect translations, and hostility from various state officials in a colonial criminal court. Also, colonial courts were often staffed with unqualified and ignorant judicial officers. The lack of any merit-based criterion for service was amply illustrated in the person of acting Chief Judge Charles Malloy Campbell, who sat in the Supreme and Admiralty Courts during Chief Justice Hume's absence in November 1847. I think he must have been so bad because I cannot find any image of him on the internet. Anyway, Campbell had only been called to the bar in November 1844, so 3 years before, and he was far too inexperienced to have sat as the colonial's chief judge. An amusing example of his inexperience was a trial reported in the Daily Mail, where the Chief Justice believed that the prisoners were named Ningbo and Changhu, towns in the Zhejiang province. And since neither of those individuals were among the prisoners at the bar, the jury was directed to acquit. It then had to be pointed out to the judge that Ningbo and Chapu were actually places along the China coast and not persons. His term as acting chief judge was marked by so many procedural mistakes to the extent that many lawyers actually decided to delay entering cases for trial pending the return of the much respected Hume in June 1848. Now, the second problem was the lack of qualified persons who could actually be employed as crown prosecutors or interpreters. And the most infamous one of these characters in Hong Kong's early colonial legal history is Daniel Caldwell. Now, he played a long-running but rather dubious role at times in law enforcement in Hong Kong, having started out as the role of interpreter in the colonial service to the Chief Magistrate Kane, and then continued as the role of interpreter for many trials dealing with piracy. So Caldwell was usually the apprehending officer, and his evidence featured in most of piracy trials in the Admiralty Court. Now, during the Chimo piracy trial itself, Caldwell was the assistant superintendent of police, and at the same time, he also acted as interpreter for many defendants and witnesses. I mean, it is a surprise that issues regarding conflict of interest or controversy was not actually, didn't actually arise, nor were objections raised more frequently regarding his simultaneous roles as, principal prosecution witness, police, and trial interpreter. Taking on the role of both referee and participant should have ordinarily called into question his impartiality of evidence and whether he was able to render impartial service, especially where he himself was invested in the outcomes of cases he brought on as prosecutor. His success was predicated on his extensive network of informers and links to the Hong Kong underworld, and he ultimately faced his own conviction of conspiracy, corruption, and conspiring with pirates in 1859. So another frequent serious issue in the Hong Kong colonial courts was perjury. Chinese witnesses would vanish after providing vague details or exaggerated evidence to the police, while pirates often had ties to local communities, and their network of contacts meant that they were able to manipulate witnesses to withdraw evidence without fear of repercussions. The fifth problem, which I mentioned bringing in the introduction, and it's the focus of this talk, is the over-reliance on the approval system. So similar to the Hong Kong Supreme Court, prosecutions in the Admiralty Court were still conducted privately by the complainants themselves, meaning that the colonial government still had to rely on the initiative and resources of the victim for bringing offenders to justice. Now, this wasn't just unique to Hong Kong. So this reliance on local informers was a central strategy utilized by Sir Henry William Sleeman in his campaign against the thugs in colonial North India. The main difference between North India and the Hong Kong experience was that in North India, there was a great emphasis actually being placed on physical evidence to support the approval statement. So once independent physical proof was proffered and unchallenged at trial, the informant's testimony was then considered irrefutable. The reason for the two-pronged approach was prudence, since there were obviously opportunities for abusing the system, which we will see happen quite often in the Chimo Bay piracies, especially because in Hong Kong, a reward was also offered to encourage popular participation in bringing the pirates to trial and for the administration of justice. So as I had mentioned before, the first session of the Hong Kong Admiralty Court was in January 1847. They sat for just 2 days. The next session was in April of that year. But by the 6th of February, 1847, 4 pirates from the Chimo Bay attack had been taken into custody, and they were seriously wounded. But the problem was they actually had to wait in prison until the Admiralty Court sat in its next session in April 1804. So by the time of the April sessions, when it finally came around, 8 men had been captured and accused of being involved in the piracy. However, the evidence against these men were incomplete until one of the gang, our approver or villain, as he turns out to be, Mr. Tuapo, comes on the scene. Now, according to his own evidence, Apo was a fisherman. He had been seized by the Chinese magistrate in Canton for other crimes, but confessed his participation in the Chimbo piracy under torture. Another witness, who turned out to have been an escapee from prison, while under a 15-year sentence of banishment, was located, and in return for him turning Queen's evidence, was granted a free pardon. So based on the evidence of these 2 witnesses, which were corroborated by other witnesses, the grand jury of the Admiralty Court found true bills against the 8 accused as either principals or accessories in the attack. Now, you would think that corroborating evidence from several witnesses meant that a conviction was in the bag. Not so. As was frequently the case in Hong Kong, problems quickly arose in the prosecution's case. The first was flaws in the indictment. The flaws in the April indictment included a charge that the defendants had launched an assault with force of arms and feloniously stole 60 chests of opium, being the property of Donald Matheson, and that of an unknown seaman had been assaulted. Well, the opium was not the property of Mr. Donald Matheson, but rather the partnership of Messrs. Jardine, Matheson and Co. And one of the wounded seamen, James Harding himself, had been called to give witness, so he could not have been unknown. So these defects were not merely technical or administrative, but they were sufficiently serious that actually 7 of the 8 accused could not be tried. And Liaman, the storekeeper of the Lower Bazaar, which was described by the China Mail to be one of the worst of the gang, since he had outfitted most of the expedition, was not even brought to trial due to the prompt discovery of these errors in the indictment by his solicitor. The second and more serious defect was actually the source of the prosecution evidence, and this continued to reverberate throughout all of the Chimbo Bay attack trials. And in the end, the only pirate convicted, Liang Moy, was not convicted of the acts of piracy committed in Chimbo Bay, but rather on minor counts, for which he was sentenced to 15 years of transportation. So Liang Moy had formerly been in the service of the police, and he was able to use the knowledge he acquired in public service, as well as his supplemental occupation as a trader, to fit out a large portion of the expedition to Chimbo, for which he received a large share of the spoils as payment. So Caldwell's evidence against Liang Moy was actually hearsay and was challenged by the defendant's counsel, Mr. Cooley. And during cross-examination, Caldwell confirmed the information he obtained from third parties was obtained with the lure of rewards. And this lure of rewards was actually in addition to the usual reward that had been offered to anyone to provide information leading to a conviction of the pirates. Now, Tuapo was finally sworn in, and his evidence was admitted as Queen's evidence. He described himself as one of those present at the attack on the Omega on the 5th of February, 1847, but obviously he did not personally board the schooner. He alleged that he was previously a fisherman, but then he had been captured and detained by pirates. And his role during the attack on the Omega was just to stand guard over the piratical vessel. He disclosed the pirates had obtained some of their arms from attacking different fishing vessels, which was a very common way for pirates to build up their ammunition store, and seizing whatever small arms they had. The pirates boarded the Omega armed with swords, shields, and boarding pikes, and plundered 52 chests of opium and some rice, before resistance was made by the crew of the Omega. Once the pirates had returned back to their boat, they set sail for Hong Kong. But before arriving, they separated the men and the opium into 2 smaller boats to divide the plunder. And at the time he saw the plunder being divided, Apo saw Liang Moy receive payment for a gun and provision. Tuapo did admit that he was told that if he gave evidence against the men, he would be forgiven of his crimes. Counsel for Liang Moy made an application for no case to answer, but this application was rejected by the Chief Justice. In summing up the evidence to the jury for Liang Moy, the Chief Judge explained that he did not consider the first count applied in the case. since the relevant legislative section relied on for the trial was actually only applicable to seamen who became pirates. But Liang was a trader rather than a seaman, so technically the first count could not apply. So the jury then accordingly only returned a verdict of guilty on the remaining 3 counts. Mr. Parker, counsel for several of the accused, made an application to the court that he objected to the charge on the indictment being erroneously made and that all the prisoners must be discharged. The Chief Justice agreed that the objections were valid and the prisoners were accordingly discharged. And this objection applied to several other cases connected to the Chimo piracy case. So a few months later, in August 1847, further intelligence led to the capture and trial of 8 more pirates involved in Chimo Bay, but these were by the Chinese authorities. Now, one of the pirates, Ko Amang, had confessed back in January that he was the one that originated the operation for the attack on the Omega and Caroline, while the other 7 prisoners admitted they had participated in the piracy and received their share of the spoils. And this is an interesting comparison as to how the Chinese mode of trial of pirates compared to the British one. And as reported by the China Mail, it was said to be simpler in nature than the Hong Kong trials. So there was obviously no need for formal indictments. So likewise, there were no technicalities or loopholes that could be raised by lawyers, leading to the accused escaping trial. Hong Amang's sentence was handed down by the Qing authorities to suffer a slow death by being cut to pieces, while the others were spared the slow death and simply decapitated, and their bodies exposed as a warning to others. It was reported that 3 of the criminals escaped either trial or execution by dying before the sentence could be carried out, although there was an open question as to whether this happened because through disease or torture. One of the other prisoners, Chung Sin, was able to prove that he had been forced by Ko Amang and his gang into the expedition by having his boat taken alongside the vessels in order to receive the plunder. His death sentence was commuted to military slavery on the Turkestan frontier. Now, banishment to the frontier areas as slaves of military personnel was actually a Qing innovation and considered a form of civil death, since the criminal was separated from his ancestral home. Surprisingly, actually, the Qing authorities were also able to recover some plunder from the pirates and hand it over to the British consul. Meanwhile, back in Hong Kong, the pursuit of the Chimo Bay pirates continued, and in January 1848, the Admiralty Court held another session in which they had an opportunity to try more pirates. This time, the 6 accused were found guilty on the charge of fitting out a boat for piratical purposes and sentenced to transportation for 15 years. But this was beginning to be the end for our villain to Apo and the evidence he had been providing to the authorities. So Apo had accused 3 men for having been pirates at Chimo Bay, or having been accessories before or after the fact. He claimed he knew the prisoners. However, one of them asserted that Apo had actually quarreled with him about a woman, and the charge was brought in revenge. At the trial, only one of the men was convicted as an accessory and sentenced to 3 years of hard labor, even though the judge informed him that a more serious sentence was deserved, but for the decrepit state of his body, while the other 2 were found not guilty. Well, then 2 more prisoners were then charged again with the attack on the very same evidence that Apo had given, and this time they were convicted and sentenced to be transported for life. These men, however, did not have the benefit of counsel, nor did they know how to make good defense in an English court, nor did they have any witnesses in attendance to give evidence in their defense. By this time, the fact that the men had been convicted on the evidence of Jess, one of the pirates, Apo, involved in Chimo Bay, was not lost on the newspapers or the chief judge. And the chief judge would probably point out that the testimony as to the guilt of prisoners was tainted by its source. However, in both cases, the jury did consider it sufficient to convict. And the newspaper started to warn against a single source of evidence from a fellow pirate who seemed to be devoting himself exclusively on reporting Chimo piracy cases by presenting 1 or 2 victims at every Admiralty session. The report concluded that since so much reliance was being placed on Apo's unsupported evidence, that it was quite possible over time that if this carried on, more pirates would be brought to trial than actually ever took part in the expedition in Chimo Bay. By April 1848, Apo's good fortune started to run out. He was finally charged for extorting money and threatening to falsely accuse another as a pirate. The jury returned a verdict of guilty, and he was sentenced to be imprisoned for 3 years with hard labor. And following Apo's conviction, the newly arrived Governor Bonham launched an investigation, and he granted a pardon to 4 of Apo's victims still in Hong Kong, awaiting transportation at the time of his conviction in April 1848. So, prior to his role as chief prosecution witness, Apo would have just been an individual with very little power or influence. However, under the approval system, he was elevated and managed to serve as an indispensable role in law enforcement efforts and a key part of the process of apprehending pirates. But in the end, it produced mixed results in relation to actual crime prevention or convictions. So to conclude, Hong Kong's unique geographical position in the South China Coast made it a contact zone between the Qing and British empires. It was located at the periphery of the Qing Empire with minimal government oversight, yet part of the Canton trading zone. And no wonder it then became a haven for seafaring pirates for centuries. With the arrival of the British in the 19th century, together with their views that their laws and their legal institutions were necessary to legitimize their rule, they sought to immediately stamp their brand of legalism and sovereignty, not just in the Crown Colony, but beyond that as well. And even though the Hong Kong Admiralty Court was meant to be a tool of empire, a base in South China to protect the trading interests of the empire and to represent state power, British imperial legal institutions were deemed to be essential to securing the empire's claim to law, liberty, and property. So the fact that it took close to 6 years before the Hong Kong Admiralty Court was properly established does throw into question its role as a pillar of empire expansion. Instead of providing a cohesive global network of enforcement of maritime claims and crime, many weaknesses within the various vice-admiralty courts throughout the British Empire were exacerbated by the geographical and personal disconnect between the imperial authority and their colonial branch officers. Outposts were just being established as a matter of course within the acquisition of each colony, and supports the claim that, the British Empire was really a patchwork quilt of colonies and territories. Now, for all the British Empire's obsession in promoting the merits of its rule of law and the superiority of its legal institutions, the fact that there was not a universally accepted definition of piracy at the time, and the uncertain laws of the sea meant that convictions based on the crime piracy was never actually guaranteed. So burdened with this disadvantageous legal definition from the very beginning, it's no wonder that the Hong Kong Vice-Admiralty Court, like many other colonial courts, then had to limp along by conducting trials with many impediments, such as lack of competent judicial officers and translators, and over-reliance on informers or approvers to prosecute pirates. Thank you.
Thank you very much, Sasha. Well, that was great.
I'm glad you're still awake.
More than awake. Lots of interesting things in there. Can I just remind everyone that you can chat in? I have got a laptop next to me so I can check for chats or whatever, but I just wanted to say the whole thing was a mess, wasn't it?
Yes, but I think that's a lot of the British Empire. It was a big mess.
I mean, it's not, I'm a little bit surprised. I know there were messes in other areas, but that just seems such a complete, it wasn't a patchwork quilt. It was strands of things going on, wasn't it? It was just completely disconnected.
Yes.
Well, but obviously it came across in so many different ways. I mean, I understand the jurisdiction idea that you said that, this is really a prerogative court in many ways. It shouldn't have been anything to do with the local colonial authorities. You can understand they would be pragmatic and think we need to do something, and if it hasn't dealt with.
Of course.
Okay.
But obviously, you had to see the reach of your jurisdiction as well, because they could have been challenged.
Yeah.
And unsurprisingly, they were not challenged more often actually by the pirates that were convicted to start off with. So, or it's not been reported in any of the
I mean, is that just again because there was no representation in many ways? So,
or it took a long time for news to travel all the way back to England and come back. Yeah, yeah. And usually, you know, what happened was the man on the ground decided the rules and made the law and made things work. Hence why a lot of the colonies were so very different. And you would think that by that stage, you know, Hong Kong in 1842, 1843 was already part of a wider empire and territory, but it's actually one of the few territories that were actually ceded and they obtained in battle. So remember, India was carried on from the British, the East India Company. So was Singapore. So they had already existing bodies and institutions in place before the government took control. Whereas Hong Kong, it belonged to Britain to start off with from the very beginning. So they had to perhaps look at the rule book. But, you know, the same thing can be said of all the American colonies as to when they were established as well. That was a huge mess where everyone was just doing whatever they wanted.
Yes. I mean, as you said, you can understand why people tried to make it work, but they didn't. Because it really didn't work, did it? I mean, that's the other striking thing. For me, I thought, particularly because, as you say, even though there's not a definition of piracy, there's been a long tradition, I think, in all jurisdictions, and really in a sort of, the first sort of international law is, it's an outrage, the whole concept of it, and it's condemned by virtually all societies, all legal systems condemn it. So,
unless, of course, you have commissioned it yourself.
That's a completely different matter.
That's a completely different matter. But, you know, I mean, that's where a lot of the gray areas did arise in, you know, is this a Pirateering Act? Do you have a commission or warrant to permit these sort of piratical acts? So, I mean,
is there ever any evidence at all? I mean, as you said, it's very difficult to find evidence about all these things. Is there any evidence that there was some sort of what we'd call today state sponsoring in any way?
Not during this period of time, although that I know I'm supposed to like talk about two cases, but it would have taken much longer. There's another case where it's not so much state sponsoring, but this was one of those boats that would accompany merchant vessels, and so, you know, they had authority to protect merchant vessels, but at the time of the attack on the Chinese junk, it was not protecting anyone, but they decided to attack anyway. So yeah, perhaps it's the time for another talk.
I was just going to say, I was thinking of the Chinese pirates, not the noble British sort of.
No, they were the noble British.
Yes, exactly.
Yeah.
But I again, thinking as you know, thinking back to earlier the history of pirates in the 17th century, whatever, and you know the letters patent that were given to privateers, they called them, whatever else at the time. But just looking on the attack on Chima Bay, it seemed. I mean, even though, as you say, I think you're quite right, these were people who just wanted to survive or whatever else, but they were quite well organised, weren't they? They seemed a lot better organised, as you know, the newspaper comments properly harshly, because considering what happened to the captains or whatever else.
I think it's more of the loss of the valuable opium and all the goods. I think, and you know, because there were a lot of merchants in Hong Kong that would have been up in arms about their goods being raised.
So no one really cared about the people dying or anything else. It was just.
No, I didn't get that at all.
But it was that thing of the pirates did seem very well organised, you know, in their attacks on the ships or whatever.
Yes, and even this is one of the few cases where they actually talk about what the pirates did. So most of the other cases that come before the Admiralty courts were actually quite sad. You know, they would be hauled in for stealing a pair of trousers. A compass, a watch, you know, it wasn't so big or so planned. There'd be other ones where people from the harbor can actually see pirates attacking vessels in the harbor itself, but they're not being captured, or things like that. So this was quite an interesting one where it did look like they were a bit more organized, but it wasn't a pre-existing gang.
Right.
From my reading of it, it looked like they were just a couple of fishermen. They saw an opportunity there, and then they rounded up their buddies. You know, the Lower Bazaar was a place where I think a lot of criminals would just hang out, and that's where they would just recruit them from. So
it was just a gifted gang.
Yeah.
They seem to do, but it was it. But again, it sort of comes in. You mentioned that about the petty crimes. That was another thing that surprised me, because you mentioned those other cases where, again, they came before the Admiralty courts, quite petty things. The gentleman who stole the cask of sherry brandy,
Yes,
or whatever, but he was found not guilty.
yes.
And again, I thought almost these courts would be sort of rubber stamping, as you say, very lack of representation for the defendants. The whole idea that really, it was a rubber stamp exercise, just finding people guilty.
So that's the other interesting thing that I did study about the Admiralty Court in my research. It wasn't just about this case, but also the fact that the grand jury and the petty jury existed within the Admiralty Court, and how they dealt with the cases. So the grand jury obviously had to find a true bill to convict them, but the petty jury will be the ones that weighed out the evidence, very similar to like the American system that we have now, which is quite unique because this is not something that you normally see in England.
No.
Or in the Admiralty jurisdiction in England itself. But they had this in Hong Kong. They also had this in Singapore.
Do we know why?
No, I surmise that they misread the rules again, as to the formation of stuff, and that's how it came about.
That's the best developments in the common law system, is there? A mistake that sometimes works in some ways.
Doesn't work. But I mean, the newspapers do go on about the fact that it's this great institution has so many people involved in it, dealing with very small minor things, that really the Supreme Court can be taking over. And because the Admiralty Court was not actually dealing with big money cases like a price and wreckage, it was just not making any money. It was actually costing the colony money.
Did you come across any cases that were to do with wreck or prize at the time?
No, not.
I mean,
our Hong Kong Admiralty Court just did not deal with that, only had criminal jurisdiction, surprisingly.
Because again, as you say, usually that's the way the court makes it money to deal with all the
or at least, at least in that time period that I was looking at, obviously, I think the Admiralty Court came back. For some reason, I've got the number of 1853 in my head, so that could have been the next version of the Admiralty Court when the colonial reform Admiralty Act came into place. Yeah.
And really, and again, any more information on some of these interesting characters? You said you couldn't find any sort of painting or representation of Mr. Acting Chief Justice Campbell, but he sounds like a great character, doesn't he? I mean,
he sounds terrible.
Relatively recently qualified, and he's suddenly elevated.
Yeah, if I remember correctly, he got in because he was buddies with someone else, so it was who you knew.
There we go.
Yeah.
That's a colonial sort of thing.
Okay, is that a question?
Oh, sorry. I probably have got some. These. Sorry.
It's all right.
I'll read out some of these questions that have come in. Thank you for a fascinating talk. Your talk was very comprehensive and surprisingly detailed. Can you talk a bit more about your sources and research methodology? Was it difficult to put the picture together? What were the biggest challenges for your research?
Sources was definitely just newspapers. And my biggest difficulty was that I was doing this during COVID, and so I didn't have wide access to more resources or being able to go to the libraries all the time. How do I put it together? Cut and paste. That's how I normally. So I think when people write this, I think two styles, right? There is the planner, and then there's the editor. So I'm definitely more in the editor sort of camp. You just put it all down, and then you have to see how it all fits in and work like a jigsaw puzzle. So yes.
Good. And sorry, I've got this one. You mentioned that civil law jurisdictions have a lot to do with the concept of piracy. Did they have a definition of piracy?
No, they didn't have a definition of piracy at all. Pirates were just considered enemies of mankind, and that's how it was. And because I think also on one hand, states that want piracy to be quite fluid, because they did not want to have their own state sanctioned actions to come back and bite them when they've gone off to say you should be attacking this country. Don't quote me on this, but wasn't the English and the Spain attacking each other at one time? And there was a lot of state sanctioned piracy going on there.
I think so.
So I think they were quite happy to keep it as fluid as possible.
I think so. I think some of at least England's foremost naval history, heroes had
yes,
had sort of checkered pasts.
yes,
At least we can
yes.
describe those as well. Sorry. Any ideas why the common law did not have a definition? So the question's coming here.
I think everyone just understood what a pirate was. You know, that's just the general feeling that I got. I mean, just looking at the legislation or the ordinances and statutes that have been drafted, everyone just knew what a pirate was. It was someone that, you know, conducted violence on the high seas. They pillaged, they stole. I guess in their minds, they didn't think like lawyers or feel the need to have to define what a pirate was. People just knew it when they saw it.
But the Qing courts, the Great Qing Code itself would have a better idea.
Well, I'm not sure they had a better idea, because one of the works that I read actually considered that anyone that you know, diminished the confidence in the state or crippled it will be considered a pirate. So they also considered opium traders pirates. So, you know, again, it's a very flexible concept that I think the states applied it as and when it was convenient to the situation.
And the sort of following on from that, with the trials that actually went on here, the big change was with the Admiralty Court being set up in 1847, but it didn't really improve things that much.
No, not at all. The newspaper has described it as a lumbering machinery, limping on. Yeah, so it was almost superfluous for its purpose, and most of the newspapers would go on about how, you know, the Supreme Court can actually deal with these petty crimes and these actions. Why do we need a completely different court? They obviously did not appreciate the finer distinction between crown prerogative granted to an imperial institution.
I wonder if that's a sort of local feeling again about sort of that external interference, that perhaps they should be left to themselves as a colony.
Yeah, but that I mean that's very interesting question to like look at, because, you know, they would have just arrived themselves. It was not as if that, you know, Hong Kong had an existing active European population here where they felt that they were being interfered with, or a system where it was already established, and, you know, they were imported themselves.
So in many ways it was, I don't know, I've heard it described as a bit of a Wild West sort of town at that point. You know, people came in, they were just making money or whatever else. So again, I think there would have been a lot of idea that you just need to deal with force with these people. Yeah, and
I think, you know, the sale of land as well was quite a wild experiment, wasn't it? It wasn't properly regulated, or
I think we still got issues to do with those original
there we
of
go.
land as well. But again, and following on, so the Qing courts, when they caught their pirates and when they tried them, found them guilty, dealt with them in various ways, and managed to recover some of the property.
Yes, I don't know how that's quite efficient, isn't it?
Did that get reported in the news? I mean, how did the newspapers, if there were reports, how did they view that? Did they commend the Qing? Or did they find it embarrassing?
I actually can't remember. It's been a while since I read that article. But I don't think there was any negative publicity about that necessarily. There was one case though, where the Qing authorities were a little bit too efficient. They were the Mandarin actually wanted to come and see who was captured, but by the time he arrived, the guards had just executed everyone, and
no more reoffending.
No.
But that's it. But it must have then been I mean, I wonder what sort of impact that had then on the Admiralty Court, because you said primarily the Admiralty Court, as it was originally set up in Hong Kong without proper jurisdiction, had failed really in finding those people guilty, even though I mean, maybe they were innocent, maybe they were.
I mean, it does show, or, if you want to look at it the other way, is it a failure, or does it show that the English system has due process and it worked? And, technically it gave a fair trial and fair hearing to whoever came before the court.
But obviously the reports there, I think, were quite critical of
Yes,
it. So I think
yes.
locals did not, they thought it had failed in that point.
Yes, of course, because these are pirates, and they did not want to have
Yes.
pirates roaming around the seas, and because Hong Kong was such a big trading port, it was a real concern to have encounter pirates all the time, even just traveling between Hong Kong and Macau. You could just regularly get raided by pirates who
Yes.
kidnap you, steal your personal belongings, and it was a real fear. So yeah, I guess for the newspaper and reporting for the population here, they might have felt that it was a failure. But if you're just looking at due process and the system itself, the legal system itself, it could be said that it actually did work. And
That's what I thought as well with those other instances you gave about people being found not guilty.
Yes,
You think, well,
yeah.
actually, there wasn't enough evidence or whatever, or there was a fault in the
indictment.
in the indictments.
You would
which,
think that they would have got it right.
Well, I would have thought so with such a serious case.
Yes.
That's it. Sorry. And there was the British colonial maritime activities seemed to be in urgent need of a definition. Did they? Do you know subsequently if they came up with a definition?
No, I don't know.
I didn't know if you
My
explained
focus of the study was just these 2 years, and
Okay.
I haven't looked at whether the Colonial Act of 1849 actually defined it. My guess is not, but I'm happy to be corrected.
That's it. I'm not too sure if there is a definition today. I would hope today we're more obsessed with definitions.
I think the UN has actually a definition, but then they're also quite. When I was reading it, it looked like there were a lot of other exceptions. That if an act fell outside of it, even though it could technically be as being piracy.
It did actually. It got referred to piracy when we were. My colleague was talking about CUHK Airport and the origins of sort of the whole idea of planes being hijacked, and why the term hijack is actually used and not the term piracy in the skies.
Okay.
And I think it was at that point we had that comment being made. It was something to do with the fact that piracy was often crews turning on their captains as well, or whatever else.
But there's another word for that, isn't there?
Yeah. They get sort of.
I can't remember it off now.
But that's it.
Mutiny.
Mutiny, sorry, yeah, mutiny was linked in as well. I think.
Yes, but when pirates, when your crew turns against the ship's captain, that is mutiny. So, yeah.
And then the concept of the approver. So, do we know how did that come into Hong Kong? Was that just a general thing again in the colonies? Or...
I don't know how that came into Hong Kong. I think what happens is, colonies would look at how other places would have operated, or perhaps they themselves had come from other colonies, and so they brought with them the system that they had used. Yeah, I mean that is just my guess. Yeah,
a pragmatic approach again, that you find someone or whatever else.
But that's how the British Empire worked. It was whatever worked on the ground, whoever was on the ground, you just made it work.
But this particular case became quite a scandal then in the end about this particular gentleman. You say because of the faults that happened, and the newspapers sort of pointing out the fact that he probably was just sort of
making money
at random and people had upsetting or whatever else.
Correct, yeah.
So I think it. Did you know? Was there any more about it being used?
No, once he got sent off for hard labor, that was the end of Apo.
That was the end.
Yeah, that was our end of Apo.
Particular character in that one.
Yes.
So yes, and then what's your next plan to do with this project? Are you moving on? Are you going to write this up?
Yeah, it's supposed to be written up like 12 months ago. Yes, I have plans to write it up.
So it will become a book? Or?
Oh no, just an article. I don't think there's enough here to actually be a book. Yeah.
Okay. Well, it was a good sharing with us today.
Oh, thank you for having me.
Well, yes, that's it. So with the whole issues to do with the piracy in the waters of Hong Kong at that point, did you see any cases afterwards to do with dealing with the pirates? Did the Admiralty courts?
Oh yeah. So I think in 1853 there's actually a book written by Captain Hayes, and he talks about the suppression of piracy. So he's written a first-hand account of his suppression of pirates, and I would have had to look at the next version of the Hong Kong Admiralty Court and what it is, but. No, I was very interested in this area because nothing's ever been written about it. You assume that piracy would have been a very big issue around here, and that trials would be pretty straightforward. because it was, you know, something that occurred relatively frequently. And but it's not so, is it?
Well, as you say, earlier there were those great fleets of pirates.
Yeah,
which
yeah.
we know about. I mean, and there've been a long history of this sort of the waters around Hong Kong being identified as did they call them the Sea of Thieves, the Portuguese or whatever else. So,
the Ladrones.
and then
but also with those fleets, they weren't necessarily punished. You know, didn't they turn those fleets towards assisting them in actually suppressing that they brought them into the navy and used them to suppress other pirates around.
I think it's one of our famous sort of heroes, local
yes,
pirates,
yes,
to do with Chung Chao and everything else.
Yeah, that's right.
But then later on, as you say, we did carry on with the problems. I think even in the 1930s and 40s, the waters around Hong Kong
were still filled with pirates.
Pirates or whatever else, and boats would be armed, even going between Hong Kong and Macau, and even having sort of having to put sort of metal
safe boxes,
and everything else around it. So it's an interesting sort of area, I think, for maybe some future research, as you say. But this period, I'm quite surprised, as you say, that no one sort of worked on it before. So we're very grateful for you for sharing.
Thank you.
Thank you very much. So thank you very much for joining us today. It just remains for me to thank the speaker, Sasha Allison, very much for giving us this long-awaited presentation on pirates, and in particular on the Hong Kong Admiralty Court of 1847 to 49. And then I've got to publicise to you our upcoming events. So the second in our Greater China Legal History seminars for this, our 9th year in this particular series, is on the 6th of October, and it's on death sentences in the Great Qing, 1744 to 1840. So it sort of ties in the beginning of your period there. So at the end of there will be the beginning of yours. I don't wonder if you'll be talking about any pirates to do with the death sentences in that particular idea. And then on the, sorry, my notes here, on the 27th of September, in our Centre for Comparative and Transnational Law, Corporate Law and Governance Cluster talks, we have a talk by Professor Harpreet Kaur, and she'll be talking about developments in the securities market in India. So that's on the 27th of September, lunchtime talk. And then we have our great friend, Professor Michael Martinek, who has been a supporter of the faculty for many years and has joined us many times online on many events. We have got another online event, but this one is also mixed mode because Professor Martinek is coming over to join us in Hong Kong as well. So we're very pleased to be welcoming him in Hong Kong on the 4th of October. That's a lunchtime talk, again for the Centre for Comparative and Transnational Law, this time for the Transnational Economic Law and Dispute Settlement Group. And that's on international commercial arbitration, what explains the ongoing boom. So you can come and join us in person or join online for that one as well. And then Professor Martinek will again be speaking for us on the 5th of October. So he's coming to visit us and we're keeping him very busy as well. This is an evening talk on the Thursday evening, and this will be part of the Centre for Legal Innovation and Digital Society, CLINS, where there will be a seminar talking about legal personhood of artificial intelligence systems. So I think that's something that many of my intellectual property colleagues, even if they're interested in shipping law as well, will be interested in that. So that's on the 5th of October. And then we have the latest in our teaching and learning seminars, which is on the 11th of October. It's a Wednesday, and it's going to be in our Graduate Law Centre. This one is an in-person event only, I think, at the moment. So if you want to come along and talk with us about the future of legal education, and of course, everyone who is a lawyer or involved in the law should have a view on legal education, you can come along and join. Well, I'm involved in that, but primarily my colleagues, Dr. Jenny Chan and Professor Michael Lauer, talking about technology-enhanced learning, challenges and opportunities. And that's the result of a research project that we've been looking into virtual teaching and learning. So lots of different issues in the way that we teach law, using technology and whether we should use technology. Over the last few years, we've all got used to being online in Zoom, and we're going to be discussing about how that will actually work with teaching and learning in law in the future. So thank you very much for joining us today. Thank you very much once again to Sasha, Allison for joining us. Well, I think we're all very impressed by how inefficient the courts were in Hong Kong in those early days. As you say, I'd never thought of it that way before, but yeah, in some ways, I suppose in the other colonies, the British sort of took over from existing organizations. And with Hong Kong, it was just a startup operation. And I would have thought they would have had some experience,
idea. Yeah, no,
you know,
they
as
didn't.
you say, in dealing with these things. And of course, being primarily at that time a maritime nation and being proud of that sort of thing, I would have thought they should have been able to deal with things, but they couldn't. And it makes interesting stories for us all. So thank you very much for joining us for our seminar today. Please join us in the future for our Greater China Legal History seminars and for some of our other seminars as well. Thank you and goodbye.